proposition that I was making. No, Chairperson, let me explain two things. One is that it looks like I needed the lunch more than everyone else. The extract that I read is just above, or rather below the one. I've highlighted on your copies the extract that I should have read, which I'll read out just for the record.
Read us passage 327.
Against H, yes. I wanted to quote against F, which is the one I've highlighted on your copy. And it says,
yes.
It says, where a question of the state of mind of an accused person is an issue, it is not easy for a court to come to a conclusion favorable to the accused as to his state of mind unless he has himself given evidence on that subject.
Yes,
that's more like
almost a self-evident observation.
Correct.
Self-evidently correct observation.
Yeah.
Yes, thank you. Thank you for the comment.
Thank you, Chairperson. And Chairperson, because of exigencies of time, what I'm going to do is I'm just going to round off 5 propositions very quickly around this issue of putative self-defense, and for the rest I'll rely on the heads. Well, 4. The first one was just to clarify this, the quotation. The second one, Chairperson, very briefly, deals with the question that you raised about warning shots. And all I want to say about that is that from my cross-examination of Captain Lust, it became clear, one, that although he called it warning shots, it's not warning shots, as we all know the term. Because I put it to him that when you do a warning shot properly defined, you obviously must create an opportunity to see what happens. And he considered that that opportunity was never created. So it can be a warning shot, as we know the term to suggest, because on his evidence there was no break. And I think the chairperson put the question to him much clearer, by saying, would if someone wanted to drop the arm, the weapons, or run away or whatever, or say, look, I give up, would they have had that option? And it was clear from the cross-examination that that would not have happened. So, just to use the word warning shot doesn't make it a warning shot. A warning shot must be accompanied with an opportunity to do something.
To heed the warning.
Absolutely, yes. Otherwise, it's not a warning, it's just a shot. Or it's what Minister Shabang would call a kill shot. The third point, Chairperson, is, and that point, by the way, is aggravated by something else, which the Chairperson discussed with one of my colleagues about, I think it was Ms. Leroux, about that in any event, after the first 4 seconds, any shots that were fired thereafter could not even fall remotely under a putative.
The order to cease fire was given. Perhaps you've got to allow for a bit of reaction time to that. But certainly, for a significant time in our context, shots continued to be fired after ceasefire had been given right down the line.
Yes. And remember, Chairperson, that the captain said, I put this proposition to him. You yourself never felt, yourself subjectively now, never felt that your life was threatened. And he said no. And then I coupled that question with the saying to him, in terms of the basic line, would it be fair to say, I'm paraphrasing, to say that you were standing at the most vulnerable point? In other words, closest to the strikers than the other people down the line. And he made that concession, which would mean that if he never felt subjectively that his life was under threat, and he was at the closest point, then as you go further down the line, so to speak, then you can't say those people would have. But it goes back to the answer. Obviously, it would be that subjectivity is subjectivity, and it might differ. But I'm just saying, on the face of it, if he was at the most vulnerable point and he never felt that his life was threatened, then the Commission is entitled to assume that none of the other people could have had even putatively thought that.
I've got a little bit of difficulty with that because he was one of those who shouted ceasefire after 4 seconds.
Sure.
Which implies that he thought before the 4 seconds expired that there was a need for shots. So I'm not quite sure how valuable that answer is, but clearly it's an answer that assists you.
Yes, thank you very much, Chairperson. And again, I won't put my head on the block, but my memory is that when I put that question to him, it was on the basis that at any stage you never felt that but the record will speak for itself now. The third point, Chairperson, is the order to engage. That, again, fortunately, it's not your job, Chairperson, to resolve that with certainty in relation to what we're discussing. But I will only go as far as to say that there is sufficient clarity or lack thereof around that issue that it cannot be said that that command to engage was not given, 1. 2, it cannot be said that it was not given as a trigger to the TRT shooting. Because remember, we have 2 independent sources of this. Vermaak says, and the chair and I had a debate about this. Vermaak says, I heard Khalid saying engage. I thought he was talking, I thought those people were pop because I was in the air, I couldn't see properly. It turned out that they were TRT. So when I repeated the engage sign, maybe either in response to Khalid or myself, they shot. But that's a bit of a long shot. The second one is Boetius. Boetius was very clear that when he had the engage, and again, in response to a question that I had put, which was clarified by the chairperson, it was a matter of seconds before he had the volley. Yes. So, again, just on those bases alone, there is sufficient evidence to suggest that far from putative self-defense, or any defense, putative or otherwise, that the shooters were shooting in response to the engage command. And I'm saying a conspectus of all these factors, crowned by the fact that the people whose subjective minds were busy inspecting now did not come and say anything in relation to what was said in Kohler's case, must do away with any notion of putative self-defense. But before I do the next 2 factors, let me quickly say this. The analysis of the evidence leaders is wrong for another reason. And that reason is simply this. It is not for the Commission to find out whether or not there is a valid defense that might have operated in the minds of the shooters. I mean, that we can't expect the Commission to do that. The point here is that in relation to the self-defense of any description, the onus, as we defined it in relation to the Commission, is on SABC. Because prima facie, people were killed, they died, they were shot, everyone saw it on television. Prima facie, it's murder, it's an unlawful killing and intentional killing and so on. And it's so I think the chairperson called it the duty of non-persuasion.
Non-persuasion.
Yes, the risk of non-persuasion.
This inquiry proceeds on 2 levels. There's the civil level, which involves really the SABC as an organization, or the minister, I suppose, really technically, and a civil claim brought against the minister for deaths sustained at the hands of members of the police service acting in the course and scope of their duties. There the onus clearly, civil case, Mabasa versus Felix, onus on the police to justify. If they can't, they fail. I think it was Ms. LaRue pointed out in her heads, of course, it's different where you're dealing with criminal liability. There we're dealing with individuals. There, of course, the onus would be on the state. and to negative the defense. And one of the factors one would bear in mind before recommending a prosecution, perhaps, or we're not going to recommend prosecution. We're going to recommend that in the cases where we do make recommendations in this regard, that the matter be investigated and the NDP, the provincial DPP.
I'm going to try and persuade you otherwise, Chairperson. But
give careful consideration to whether it should be looked at. But as far as the criminal level is concerned, of course, the onus wouldn't be on the accused, and one has to bear that in mind as well. But certainly on the civil side, Mabaso versus Felix, I would imagine,
yes.
Occupies all the ground you need.
Thank you, Chairperson. That's yes. So I just wanted to get that out of the way. The next of the points is Ndamo's case. It's quoted, I think, in one of our heads, either the reply or the but the citation, just in case, is 2001 bracket 1 SA 830 TK Big H, Transkei High Court. And that was the case that was referred to by my learned friend, Mr. Chaskalson, a judgment of Madlanga AJP, I think, at the time. And that case is authority for the following proposition, and I'm not going to canvass the facts or what happened there. Simply that when you are looking at the state of mind of police officers, you can't apply the objective standard of the reasonable man, so to speak, or person. But you must apply the reasonable police officer. And I would go as far to say, in this case, the reasonable TRT police officer. Knowing that you have lethal force in your hands must obviously impose certain extra duties. And apropos that, Chairperson, let me say this. You can, if you are a TRT person and you think that the strikers with pangas or whatever might attack you, you have your sidearm with you, but in anticipation you bring a machine gun automatic rifle and you cock it before the attack materializes, then I'm afraid from another point of view of proportionality, again, whether it's putative or self-defense proper, you are out of either those or either one of those two.
I haven't studied the case. It's one of the things I shall do when I go home at the weekend. Isn't the proposition essentially upheld by Madlanga AJP, as he then was, that in deciding whether a defence or self-defence is made out or excluded, you don't just look at the events that happened during the so-called attack. If you did things beforehand which indicated you planned incorrectly for the situation, and it's in line to some extent with the ratio in the Macan case. Now, the police seem to contend that Macan is international human rights, European human rights law. It's not part of the ratio is not part of the domestic law of South Africa. And that's one of the matters we have to grapple with as well. And you remember I put the example of the homicidal criminal who's at loose in a building, say a police headquarters, and he's running down a passage, and you can get him to go, and there's a T-junction, you can get him to go left or right. If he goes right, left, you lock him up in a room, he can't do anything. You let him go right, he will be in an office with people who have got guns. It's foreseeable that there will be a shootout. It's foreseeable that people who will be under attack and will be defending themselves, they will be, as the people were in McCann's case, they will be free of liability. But that's not the end of the matter, because the person who decided to allow the person, the criminal, the homicidal criminal, to go right, when he was able to arrange for him to go left, would have liability. That's the example that I invented, thought of. If that's the law, there's no clear authority on it, but if that's the law, and it seems to be sensible, if I say so, then the Macan principle would be part of our domestic law.
Absolutely.
And it would be strange if it wasn't.
Yes.
So
that's correct, Chairperson.
Not surprisingly, you support that proposition.
It
may be that Mr. Semenya will be able to show the logical fallacies in it.
Thank you, Chairperson. And just for the sake of completion, this is what Madlanga said briefly, so, having canvassed the facts. The point of the matter is that if the police had not acted wrongfully in the first place, for all we know, there might not have been any life-threatening shooting at all. One cannot simply ignore this fact and, so to speak, start on a clean slate. The preceding unreasonable conduct of the police cannot provide an acceptable excuse for the subsequent use of lethal force. I again emphasize that the police bore the onus to prove, okay, well, that doesn't apply here, that they failed to do. I'm well aware of the caution against adopting the armchair approach and so on. And then, importantly, after that, it says, if I'm wrong on the proposition put forth above, I must consider the question of proportionality, which is the point that I just made.
The first section would appear to deal directly with the example I put up.
Absolutely.
Of the man who's running down a passage to a T-junction, and he's sent right instead of left. Yes. And people in the room correctly, justifiably defend themselves. Yeah. But that's not the end of the inquiry.
Yes, that's correct. Thank you, Chairperson.
That's the Macan principle.
That's the Macan principle, yeah. In other words, on the Macan principle, my argument now is that the police fail on both legs, because Macan says, well, the mere fact that there might be a defense of private defense for the individuals does not mean that the state or the institution or SABC in this case is...
Well, to apply that principle to the facts of this case, a possible application of that principle to the facts of this case might involve the following approach. I'm not saying it's correct, I'm just putting it up for people to consider. That if the police had stuck to the first plan, which Scott had done, compiled with the benefit of Marafi, and there was a lot of public order policing input, and had carried it out on the Friday morning, waited till the Friday morning and done it, they might have disarmed the people, dispersed them, arrested the criminals and so on, without any bloodshed at all. Because, however, it was decided not to adhere to that plan, for reasons that we know, and to go into another plan, which arguably was a foolhardy, risky plan, which may have been the only one that Scott could have thought of at the time available, but that's another matter. Even if the people who were caught up in the situation created by the second plan were able to, their shooting could be justified, even that was so, then it doesn't get the police off the hook.
Absolutely.
On the Macan principle, if it applies.
Yes, that's exactly a summary of the Macan principle, Chairperson. The last point is maybe a technical point, but one that we have raised in the heads. And that is that if you read the terms of reference, the applicable part says that the Commission must find whether the conduct of SABC, I'm paraphrasing, was reasonable and justifiable. In other words, it doesn't say and or. So in theory, if that is correct, even if one were to find that it was justifiable under what we've called self-defense proper, it still has to be reasonable, and vice versa. Even if one were to find that the mens rea element was missing under putative self-defense, it still has to be justifiable, as the terms of reference read now. So you can't have it both ways, as it were. So even on the most benevolent approach which can be taken, it would be that SABC then has not shown that their conduct was justifiable and reasonable. At best, they could show one of those two. Certainly not justifiable, because self-defense proper is, on our submission at least, is out. But maybe, depending on what the Commission finds on putative self-defense, may be reasonable in the sense postulated by the evidence leaders. That, nutshell, Chairperson, is the big point really is that all this pales into insignificance if one looks at the objective evidence. The objective evidence shows us that any policeman who was there with his eyes, seeing these people avoiding and running away and trying to and coming towards, and that's what the world saw, Chairperson. The world wants to know what happened at that crucial point. The world saw people who were. The world didn't know about these things, about that there's a tear gas behind them and so on. But what they did see were people who were huddled up with blankets, and they are covering themselves from the tear gas and the yes. And that is what a policeman there saw. So there's no way that subjectively or reasonably or otherwise that policeman, having seen these people for the past 9 minutes walking about there and being able, more than all of us sitting here, to read their demeanor, to see what we now see on the television screen, how could they ever have thought that they were under attack? They couldn't under those circumstances. So just to round off that point. So the last vestige of any justification, using that word broadly, of the shooting of the people, which was the putative self-defense, must fall away. And the consequences that follow is that both SABs and the shooters must be found to be criminally liable for their actions.
SABs being criminally liable?
Well, yeah.
Prosecute the South African Police Service?
Well, yeah, no. And Section 332 doesn't apply to them. It applies only to lawmen, yes. But, and as Bechel says, that would bring a situation where the state would be the prosecutor and the accused. So we can't have that.
Sounds like a divorce case, the state versus the state.
Yes, the state versus the state, yeah. Now, moving to... Moving to the question, I'm not going to deal with Sin 2 or any of those, Chairperson. That's been canvassed. Let's now go to the question of criminal liability, starting broadly, but also dealing with the question of the criminal liability of Mr. Ramaphosa. Again, to avoid the state problem, we'll just say the people versus Ramaphosa and others. The crucial thing, why we say Mr. Ramaphosa should be accused, number one, in a murder case, is this, Chairperson. Let me put the proposition broadly first. In fact, I'll use the LRC. The LRC has two lists of accused persons. The one is of the police accused, let's call it that. It starts with Minister Mthethwa. And the other one is of the lawman accused. It starts with Mr. Mokoena. And my learned colleague, Ms. Barnes, amended the one list by adding Mr. Ramaphosa on the one. And my argument is going to be that he should be added on both lists. That whichever way you look at it, he is the first accused on both lists. And I'll explain why. If you look at it from the point of view of the commission of a crime, then he must certainly be on the SABS list of accused, as the first accused. If you look at it from an alternative point of view of the omission to do something and so on, then he must be accused number one on the lawman list. And those are two separate legal bases. Obviously, you can't charge them twice for the same thing. So it would be an alternative charge, as it were. But putting that aside, the very idea, Chairperson, that you can, and that's why I go as far as to say in my head, if you're not going to charge Mr. Ramaphosa, don't charge anybody. Really. Because you cannot have a situation where the source of the political pressure, the person who ignited the whole, what I've called the chain of causality, which resulted in the massacre, where the provincial commissioner says, we must do this in this way, in this fabled way, or befuddled way, because we are responding to the political pressure. And I don't want to belabor that point, because my understanding of what the evidence leaders are saying is that there's no quarrel between us, and I'm sure not anybody, that Mr. Ramaphosa was the factual cause of the massacre to that extent. Where we seem to part ways with the evidence leaders, because they say there's a contradictory part of what they say. At first, they say it's inexplicable why the decision of the NMF was taken. But in another section of the heads, they say it can only be explained through the political pressure.
Probably different authors at work.
Yeah, that's what I suspected. But be that as it may, and I plead guilty to that as well, because the timelines were quite tight. But the point is this, Chairperson. Let's talk about this legal causation. Firstly, even if they were right on legal causation, which they are not, it would not resolve the question of whether or not there's a prima facie case. Because let's postulate a case where, Chairperson, given the test that we've all now agreed on, because yours is not to find anyone guilty or all those things. If I say to you, Chairperson, I've presented now a case here which shows that Mr. Chaskalson unlawfully and intentionally did and caused the death, but for now I can only show you that he was the factual cause, because I saw him there and I saw the dead body. But I can't tell you whether he was also the legal cause and so on. Surely that alone satisfies the prima facie case. So, because the legal niceties of legal causation are not for you to determine, Chairperson. Those niceties are for the criminal court to determine. But that's just to show that it's inescapable that these criminal charges have to be recommended. But let's take them at face value on the legal causation. Legal causation, Chairperson, is one of these refugees of lawyers. Legal causation, in fact, one of the authors, Bobeck, even goes as far as to say it does not exist. I don't go that far.
I must say, I've always been unhappy about the expression. In civil law, I prefer the expression remoteness of damage.
Absolutely, yes.
But there's high authority, including the appellate division, which use it, and no less a person than Chief Justice Corbett, who uses the expression. So I'm happy to defer to a jurist of that eminence.
Me too.
But legal causation is almost a contradiction of terms.
It is.
And one of the judgments I wrote, I quoted a German judgment, I think, that said that long as one realizes that it's nothing to do with causation at all, it's remoteness of damage, really. It's something that happened was so remote that the factual causal chain is cut.
Absolutely.
But let's not get involved
into that.
in fights about terminology.
No.
It's the concept
we know what they
we
mean.
have to apply.
Yes. Thank you, Chairperson. We know what they mean. Actually, the way to put it, Chairperson, is whatever you call it, any lawyer must accept that there must be limitation of liability. That's really the topic. That's what it should be called, limitation of liability. You can't simply say, well, the factual cause, therefore, just from common sense. Because then it would mean any factual causation of anything is so the point that the authors make, but the most important distinction is that is the legal causation, as the chairperson correctly put, like Professor Zeffert says, it's like the Holy Roman Empire, which is neither holy nor Roman nor an empire. So it's neither legal nor causation. It's actually a question of negligence and the limitation of liability using whatever legal instrument. And that is why its evaluation is based on policy considerations, which is what I've just described, that you can't say all factual consequences of something are either civilly or criminally or create responsibility. So the real issue is intention, is foreseeability. Because remoteness, the only way you can test remoteness is about whether something was foreseeable or not. And remoteness, whether I've quoted Sneyman, who says that legal causation straddles both intention and causation, explaining what I've just said. Remoteness must feature only like this, that the consequences of your actions were so remote that from a public policy point of view, you should not suffer the obvious consequences of those consequences, if you know what I mean. And that's all there is to it. And what does the law then do to look at that? The basic statement is that foreseeable consequences cannot be remote. It's another contradiction. So in the eyes of the law, what you can foresee must be in the mix. And that's why we come with notions such as dolus eventualis and so on. Because dolus eventualis, for all its justifications, creates a situation where it's 50-50 as to whether the intention was there. But from the eyes of the law, it's a fiction, so to speak, that is created so that in the eyes of the law, whether I am the man or the woman who sets alight my shop because I want insurance money, if I can foresee that there's somebody there, then I'm as much of a murderer as the other person a serial killer who goes out with full intention to go and kill. And all the other questions will be questions of sentence and so on and so on. But the foreseeability, another serious mistake that is made by the evidence leaders in the effort to exculpate Mr. Ramaphosa, is mixing up again mens rea with motive. The law is very clear on this. I've quoted it in my head. The motives of a person have absolutely nothing to do, from a legal point of view, with the consequences. Again, give this example. If I set my house alight because I want to claim for insurance, that's my motive. But if I foresee that there's a human being, some hobo who happened to be there, and I don't check whether he's there today or not, then the intention in normal English, when we talk in the street, that statement would be like ridiculous. What do you mean intention has nothing to do with motive? But the law separates those two very clearly, and that is also dealt with in the case of Kola and whatever other case I've quoted in my heads. So even accepting, which I don't at all, even accepting that Mr. Ramaphosa was motivated by this civic duty because he was worried about Mr. Fundi and all the others, even accepting that may well have been his motive. But his intention, legally speaking, is only tested according to the following principle. Was it foreseeable that deaths would occur? Was it foreseeable that deaths would occur? And was he reckless as to whether that occurs, and did he not do whatever needs to be done? The whole dolus eventualis formulation, if we take it at its minimum. So there's only one question: it's foreseeability. Whether you approach it from To Lucy Venturali's point, whether you approach it as so-called legal causation, it doesn't matter. The issue is, were the consequences foreseeable? Now, Chairperson, with the greatest respect, here is a man who, I say to him under cross-examination, and as I've said earlier in the morning, you were aware that there was this volatile situation, yes. You were aware that people had been killed, yes. You were aware that they included police officers. You were aware of, let's call it the standoff, yes. Now, if there's a standoff, Chairperson, with a group of 3,000 miners who, to your knowledge, at least, or mistaken or otherwise, have killed 10 people, as what was being bandied about, and are refusing to leave a copy. And your solution to that is that they must bring another 1,000 policemen and the army and all that. How on earth can it be said that you do not foresee, if you are a South African, well, whatever, even if you are not a South African, that there's a possibility of people dying there? Surely, let alone if you are a person who knows the mining industry more than all of us, who knows the temperament of miners, of what, once they've decided on something and all these things, and you know what happened at Impala, you know all these things. How, I don't understand how it can ever be argued that you do not foresee the eventuation of death. You cannot. Here's a man, Chairperson, and here we must not forget about the fact that this is a deputy president and so on. In the eyes of the law, he must be treated like everybody else.
He wasn't the deputy president at the time anyway. So
well, he is now.
I know, but that's relevant.
No, he was, exactly. No, I'm saying we must forget now, because so that he can face the...
high officials can be charged with offences even while they're in office.
Thank you.
There's a judge president somewhere in the country who's being charged with something. So,
I know. So, in the Eastern Cape. That's correct, Chairperson. No, all I'm saying...
There's always no respect to a person.
Thank you, Chairperson. Yeah, with all due respect. But again, here's the person. This is not just any person, Chairperson. This is somebody, Mr. Nsabeza yesterday spoke about all the massacres that have happened before. Well, let me tell you this. Speaking for myself, this is my second massacre. I was in the Bisho massacre as one of the marchers there. And the soldiers shot people and killed them. And who was leading that march? It was Mr. Ramaphosa. He knows, Chairperson, he knows that if you bring the army into a situation like that, or these specialized units, or many policemen and so on, death, I won't say is almost certain, but it's definitely foreseeable. So here is somebody who, armed with all this knowledge, goes along, and I accept that the army was not brought and so on, but goes along with a sentiment that says this thing can only be resolved by bringing the police or the army. And we are told that he thought, I don't know, the army is just going to come and hug these miners there and I don't know, or give them a lift to go home. The army is a machine that kills people. And the chairperson corrected me when we were in Rustenburg. That's not its only function. But, you know, we all know that once you say, look, this situation, here are these people sitting here in the Falam Commission. They are refusing to come out of the council chamber. Let's bring in the army. You can't. You can't then say you're not foreseeing the loss of life. What you are doing is to say, whatever, and that's where motive maybe it becomes important. Whatever the risk of loss of life to those people sitting in that auditorium, there is some other important consideration which supersedes that loss of life. And in the case of Mr. Ramaphosa, that consideration was his financial interest at worst. At best, it was what I referred to in the morning, the desire to shield the NUM from its fortunes of dwindling membership. Doesn't matter which one it is or both. The point of the matter is that no one, and this is not, again, Chairperson, this is the chairperson of, ironically, the previous day, on the 15th of August, on the day that he's sending these emails that they must send the army and the police, he was flying to Cape Town for the adoption of the National Development Plan. On that day, literally, when he saw Minister Shabangu, he was there for the National Development Plan. What does the National Development Plan say? It says, this militarized police that we have here is brutal, is using, I can't remember the expression used, of trying to solve every problem by use of force and so on, and hence it should be demilitarized. So he's the last person to say he doesn't know that he was sending a brutal police force into what, at least, let's give him this, a brutal group of people. So he was orchestrating this clash of brutality because again, let's give him the due that he was rightfully shocked by what had happened and so on and so on. But that alone is aggravation because it shows that you are now saying these brutal people must go and confront these other brutal people. So, with the greatest respect, any suggestion of not foreseeing death there is just fanciful. And I'm not saying he might not have foreseen it in the same terms as the people on the ground, the 20 deaths or Tatane, all the other people who clearly foresaw deaths. But in his own space, he certainly foresaw death. And remember, Chairperson, there's law on the question of the evidence leaders say that, well, he certainly didn't foresee that 34 people are going to die. It doesn't matter whether he foresaw 5 or 8 or 34. That's irrelevant. And then there's the other point which gets bandied about. Oh, well, then why did he have arranged a meeting with the NUM people on the 17th? It does not matter. He does not have to foresee that the people are going to be killed on the 16th at 4 o'clock near the kraal. That's not what foreseeability is. There is ample law which shows that you do not have to foresee the causal sequence of your actions. You have, and I've cited the cases in my head. The mere fact that even authorities which come from S versus De Bruin, which it's probably referred to in my head. Yes. Say this, Chairperson. I just want to make this point before I read this, because it's just a quick point. Those, the 34 and the 17th, go out of the way, because what the law says is that if you see the foreseeability of death, even if it's remote or slight, that is sufficient to bring you into the realm of dolus eventualis. And this is what was said by Holmes, J.A. in De Bruin. Secondly, dolus eventualis, he was explaining the different thing. The accused foresees the possibility, however remote, of his act resulting in death to another. Yet he persists in it, reckless whether death ensues or not. On analysis, the multiple characteristics of dolus, and then he talks about subjectivity and so on. But the key issue that I'm communicating now is that this case and many other subsequent cases. It's at 510. What I've just read is at 510 of the judgment, Chairperson. The citation, I'm sure it's in my head, but just in case, it's 1968 4SA 498 AD. And that judgment, that it has been approved subsequently in S versus Sheikh and others, which is also an AD case. That is 1983 4 SA 57 bracket A at page 62. 62, Chairperson. Yeah.
2009 decision van Aert.
Yes. There's another case, S versus Van Aert. I'll find the citation.
Authorities for the same proposition.
Yes.
And you've got at least two appellate divisions.
Yes, that should be sufficient. Yes. Thank you, Chairperson. And the principle there is quite simple. And it is that, I don't want to restate the principle, but let's come back to the facts here. What that means, therefore, Chairperson, is that, and the reason why there's this huge concealment, going back to all the things that have been concealed from us here, can be that it was obvious even to the minister, the police, and the national commissioner that had you commissioners known that the decision to rush the operation on the 16th was as a result of this political pressure, then you would have naturally wanted to probe as to how far it went. And so what had to be done was to deceive you into thinking that the decision was taken on the 16th. The reality, and that is why, as I said earlier, General Piecha has to remove all references to the minister and so on. Because it's just a scheme to deceive the commission into believing that this was an operational decision and not a political one. And that is why even the minister, in his own affidavit, Minister Mteto, makes what would otherwise look like an innocuous mistake, quote unquote, when he says, when I received the call from Mr. Ramaphosa, I phoned the National Commissioner. When I cross-examined him, it's clear that nothing of the sort happened. He phoned the Provincial Commissioner. Why is he deceiving the Commission again on that? Because he knows that if the truth is told, it will be clear that he jumped the National Commissioner for whatever reason. Maybe she was not answering, I don't know, there might be a valid reason. But that he jumped the National Commissioner and delved into the operational area. That's how much the pressure was. And spoke to General Mbombo. The conversation that General Mbombo in Triple J 192 is relating is the conversation that was direct, that happened between her and the Mr. Ramaphosa. But she also refers to a separate discussion which happened between the minister and the National Commissioner. That's the one that says, who are the shareholders, and so on and so on. The National Commissioner says, oh, I get it. Yeah. So that means there are two separate discussions, one between Ramaphosa and Mbombo, which is reinforced by another discussion between Mtetwa and Piecha, all of which culminate in the same thing, which is that there is pressure from a politically high person, and hence we must kill this thing, and so on and so on. So you can't, with the greatest respect, if you're going to charge Minister Mtetwa, who really, his crime is that he was the conduit for the political pressure, or if you're going to charge National Commissioner Piecha, I dare say that of all these people, if anyone can get away with it, it would be the National Commissioner. Because the National Commissioner, I think his problems arise from the National Management Forum. But in this connection, she clearly did not, the innocence with which she must have asked that question, she says, the minister says he's being pressurized by the shareholders. Who are these shareholders? It just shows that she didn't even know who was the shareholder. And Mbombo says it's Cyril. and Mukwena, very interesting discussion. Mukwena, before all she had to say was, there's a politically high, and he says it's Cyril. He knows, because everybody knows who is the exerter of the political pressure. So, with the greatest respect, Chairperson, it can never be said by any stretch of the imagination that a person who clearly foresees the deaths of other human beings and acts in that way, and those deaths actually do eventuate, in whatever way, on whatever date, did not foresee that happening. So that's the side of as I say, topping the police list as accused number one. If you go to the omission. Yes, Chairperson. Yes, so on the alternative charge.
Mr. Ramaphosa, I didn't turn my machine on. The answer is yes.
Sorry, Chairperson?
Are you still dealing with Mr. Ramaphosa?
Oh, yes. The answer is yes.
Yes, I didn't turn my machine on. That's why.
Oh, yes. Thank you, Chairperson. Yes, and I'm not going to be long. I just want to deal with the flip side, the omission, list of omission accused, so to speak. Again, what have we got here, Chairperson? We have a person who has made, I can't even count them, concessions, rightfully so, to myself, to my learned colleagues, that, and to you, Chairperson, and to the Sunday Times, and to everybody, where he says, I take personal responsibility for what happened. The Chairperson, in fact, when I questioned him on that article, the Chairperson made it, took it further and said, use the word personal. We hear this thing about collective responsibility and what have you, but do you take your share of the personal responsibility? He said yes. It's if that reference is not in
I remember
you remember that?
I remember the passage.
Yes,
he
you
talked
will
about
find
collective responsibility.
Yes.
And I said, including himself, and I said,
Yeah.
well, what personal responsibility do you take? And
Yes.
he answered,
Yeah. Thank you, Chairperson. But that's just one reference. Every time this question was put to him, do you accept responsibility? Yes. And I even went further and said, do you accept that had you not omitted to do what a person in your position should have done, all the 44 people, not just the 34, all the 44 people might still be alive today? He says yes. So on what possible basis can somebody who has come here under cross-examination and gave a confession on that score, so to speak, or at best an admission, and we are told that there's not even a prima facie, Chairperson, not beyond reasonable doubt, not on balance of probabilities, but on a prima facie basis, that omission is not criminally actionable. Then why must we charge anyone else? Why must we even charge Lonmin for omitting to speak to the strikers? Because it is that very same omission that Mr. Ramaphosa, who is a skilled negotiator, who's a former trade unionist, who knows the importance of intervention by negotiation, he's just, as I pointed out in my head, he's intervening by negotiation right now as we speak in Lesotho. He did not say there, no, shoot each other first and then we'll negotiate afterwards. He knew that, but you have to go there and get those people around the table to avoid the deaths. You can't say to kill each other and then you'll stabilize the situation. When half of the people of Lesotho have killed each other, then that will stabilize the situation, and then it doesn't work that way, to his knowledge. And once again, Scott, and this is a moment where I must say this good thing about the police plan, such as it was, that Mr. Ramaphosa's intervention actually had the effect of subverting that plan. According to what Scott says in the passage that I've quoted in my replying heads, their position, and I think the police have pushed that case successfully, was Lonmin, go and talk to the people and we'll deal with the security situation and so on. And they were fobbed off for various reasons that we know. But that was their outlook on the sequence of events. The Lonmin people must talk to the workers and they will deal with the rest. It is only through the intervention of Mr. Ramaphosa that sequence, and Jamieson and all the others, that sequence is suddenly subverted. No, now you must stabilize, quote unquote, with pointed action, concomitant action, and then, he says in some passage, then maybe after that there would have been an opportunity to negotiate. That cannot be. That cannot be the mindset of a person who, just on the basis of that omission, does not foresee the obvious consequences of that approach, the disastrous in any situation. You know, war, as I've said in the heads, does not create peace. Peace is created by the negotiating table. The fact that sometimes peace eventuates after people have had war is unfortunate. The correct situation is to avoid the war. And you can't say, let's have the war and then the peace will follow, which is exactly what was being done. Because now it was the gung-ho thing. It is not a labor dispute. Why? Why this big emphasis? It's not a labor dispute. It is so that do not even think about saying they must go to the table. Bring in the army. Bring in the police. It's concomitant action all the way. The only reason why that message was being sent so forcefully was, in fact, you don't even have to infer. Jamieson says, the opening line, he says, the minister this morning, Minister Shabangu, was on the radio saying this thing we must resolve it around the table. And that, although it's not too damaging, it's not helpful. How can it even be remotely damaging to say people must talk and resolve a situation? Because that's exactly what should be done. Instead of twisting the logic and pressurizing everybody around who has decision-making powers to change their characterization and call it criminal so that they can bring the big guns literally in. So whether you look at it from the point of view of of what he did, or from the point of view of what he did not do, then it's very clear that, as I say, he's accused number one on both the state list, so to speak, and also the Lonmin list. And if by some miracle I'm wrong on that, then surely he should be charged. As we know, that culpable homicide is a competent verdict. But let's assume it doesn't even come through that route. Then how can it be said that there's no prima facie case that a reasonable person, a reasonable skilled negotiator, a reasonable former unionist, a reasonable former secretary or general secretary of NUHAM in his position would not have foreseen that deaths were almost certain going to eventuate? Everybody did, Chairperson. Let's be blunt about it. The reason why there was Reuters and CNN and all these other people there is because everyone knew that there's a standoff there, and one of the ways in which it's going to be resolved is something quite violent. Then nobody would have said, okay, well, we know that there are going to be 34 people around the kraal and all that. But the reason they were there, it was not just because there's some other old strike in South Africa. It's because everyone knew that there is a major standoff where there's likely to be bloodshed, as everyone said. Bloodshed, as Mbembe said. Bloodshed, as Mbombo said. And bloodshed, as anyone else surely must have foreseen, let alone one who is, one of the authors of the Constitution, Chairperson. Really. This Constitution says very clearly that the police must not be involved in making political considerations. And one of the people who wrote that Constitution causes that to happen, causes the minister to cross the line, causes the national commissioner to cross the line, causes everyone to cross the line, that the lines that are set by our Constitution. And we're told, oh, I don't know, what? It was inexplicable, or some words to that effect. It's not inexplicable. It's directly linked. It is directly linked to the NMF decision, as we explained in the morning. It is directly linked to the D-Day announcement. It is directly linked to the Borscht operation that followed it, and it is directly linked to the deaths of those 34 people. And it is the omission side, that's the commission, what he did on the 15th. But the omission, which starts much earlier, is directly linked to all the 44 deaths. Because remember, Chairperson, this is not some innocent, as he tried to make us believe, non-executive director. This is a person who was in the board meeting of the 25th of July, quadruple J10, where the decision was taken that the strikers must not be engaged. So he's part of a decision that says the strikers must not be engaged. Why? Because it's going to cost us a lot of money, because other people will come and also want to negotiate. This is said by an organization that knows, as we know from their slides, that the NUM has lost ground. Technically, yes, they are still the recognized union and so on, but they know that these are not the people that have the confidence of the workers. And yet they adopt in a meeting a few weeks before the massacre a resolution that says they must not be spoken to. That decision clearly was what informed the Jamisons and the Mugwenas of this world on the 10th of August from saying, we're not talking to these people. And as I said this morning, from that point on, we were on a road to nowhere. The list is endless, Chairperson. That list, endless as it is some of it is in my replying heads. But the point of the matter is that on all these, nobody's asking you to convict the person. And if the chairperson is inclined, not my own submission would be that the chairperson is quite empowered to recommend a prosecution. But if for some reasons the chairperson is inclined only to recommend an investigation and so on.
Recommend investigation, you don't know what the investigation
Yes.
will produce.
Yes.
How can you then say whatever the investigation produces, you must still prosecute?
It produces.
That wouldn't be right.
Yes. No, I think that's sensible, Chairperson. But the only subject to this, for that approach, the test is even lower. Because if I was banging my hand on the table to say, well, Chairperson, I want you to recommend no investigation, go straight to the NPA's office and so on, then I would have to satisfy you that there is a prima facie case on the basis that a reasonable prospect of a successful prosecution and so on. But if, as the chairperson has postulated, all we're saying is that there is sufficient in front of us, or as the Human Rights Commission has called it, a reasonable suspicion of a crime being committed here, and DPP, then surely that has been eminently satisfied in this case. And we must resist the temptation, Chairperson, of creating the impression that there are, and I'm not saying that there's any suggestion of that on your part, Chairperson, but in the public eye, that there are separate, different rules for different folks. Because I'm saying now, anybody, if it was Mr. Makidiwana or Mr. Pacha, and we say, we now know for sure that Mr. Makidiwana or Mr. Pacha is the person who, the day before Mr. Twala was killed, was sitting in some room and saying, this Twala chap, you know, I saw him doing this and that. I think, you know, we must do this, that, and the other. Whether he was there when the trigger was pulled, that would have been enough, at least for the commission, to say he must be investigated for a criminal offense. He might be, whether, and it's not for the commission as to whether he's an accomplice or part of a common purpose and all these nice things. Those are considerations that will be taken by the DPP. But let's postulate, let's say a ground is found for accomplice liability or even common purpose. Then what was said, I think, by Mr. Gotts yesterday about the clear foreseeability on the part of Mr. Jamieson, where there's no question. He says, look, we foresaw that things might happen, but maybe we thought the police might. That part of the law would say that you don't need causation, legal or otherwise, because common purpose doctrine is meant exactly for these situations where you don't have to attribute the causality for each of the participants. So I don't want to go down that line. I'm simply saying, Chairperson, we don't want the theoretical discussion as to whether it's a co-perpetrator or a perpetrator or an accomplice or whatever. The point of the matter is that there is sufficient evidence in front of this commission for him to be charged with the crime of murder and alternatively culpable homicide, just as it would happen with anyone else who's not a deputy president.
It's 3 o'clock now.
Yes, Chairperson. Well, yes.
We've got your written heads, both your main heads and your replying heads.
Yes. No, Chairperson, the arrangement is...
You were arguing the aspect in respect to Mr. Raposa on the basis that a lot of what you said would apply mutatis mutandis to the others.
Yes. Yes, no, there's no doubt. Chairperson, let me just explain something about the time. The arrangement is that I have, because there's no other time on the table, I'm going to eat onto my reply time on the space or the hope that it will be recovered either through Mr. Tips or Mr. Semenya's brevity or respective brevities. Yeah. But if that doesn't materialize, then I'll eat into my own time. But I will try not to eat all of it up.
Well, may I suggest then that before you eat some of your reply time up, we drink some tea. We'll adjourn for 15 minutes.
Thank you, Chairperson.
What happened to the hours that were granted? That the combination of the putative defense